ladies and gentlemen, thanks very much for coming. So today's CPD is by our newest floor member, Geoffrey Phillips. Wonderful to have him back. Geoffrey was very instrumental in my formative years at the bar. He shepherded me through the tough times as a reader and as a junior barrister, so I must thank him personally very much for that. Max, welcome. Speak of the devil. And it's great to have Geoffrey on the floor. Now, as part of the preparation for this talk, I attempted to assist Geoffrey with some research on the US experience of judicial bullying. It made me consider whether or not the advent of media in courtrooms had in any way tempered this issue of judicial bullying in the US jurisdictions. And notwithstanding that a lot of trials are videotaped there now, I came across a couple of examples. I hope that this doesn't cut across your examples, Geoffrey, but one involved a judge. His name was Judge Watkins. He was dealing with a situation where one of the parties in front of him had given an interview outside the courtroom, and the interview was then subject of a news report which involved a picture of the judge's house. So then when the litigants turned up before the judge on the occasion of the trial, and I'll read from this, Watkins started the hearing as follows: Mr. Hage, if you say one word out of turn, you're going to jail. Do you understand me? This is the opening remarks. Shut up, don't even speak, you disgusting piece of, apparently inaudible, but it turns out that was human garbage. He screamed at Hage during most of their exchange. Judge Watkins later recused himself from any other proceedings in Hage's case, admitting he had lost his temper. So you would think that was crossing the line, but the late Justice Scalia, commenting on these issues in the Supreme Court, explained in a case, Litecki, he said, federal judges are not immune from feelings of anger, annoyance and impatience. In fact, justified and well-regulated judicial anger can be a productive force that does not detract unduly from the work at hand, nor does its expression unduly disrupt either the mechanisms or image of justice. So that was Scalia's view, but he was known to be a fairly bullish and interventionist type of judge. But whether or not that sort of language strikes the correct balance between improper behaviour and legitimate judicial discourse remains to be seen, and I think Geoffrey will address that very question. So, thank you, Geoffrey.
Next. Thank you, Tom. It's a great delight to be back in State Chambers, and a great delight to be part of these talks which you've organised. I think that it adds to the intellectual rigour and lustre of this floor, and I'm delighted to be back, and thank you very much for the welcome. And thank you also for your assistance in preparing a number of documents for me, papers to read, which are of great use. I appear over the last couple of years to become a bit of an expert in judicial bullying, not because I've been bullied much, but because many years ago I was asked to speak at a heads of government departments for the New South Wales government in relation to workplace stress in the public service. And I decided that I've never been a public servant, but I talked about my workplace, and my workplace was being barrister. But at that stage of this talk, it was in 2003, I'd been a barrister since 1982, and first legal job started in 1977, and I'd recognised that a lot of people at the bar, particularly because at that stage I'd been at the bar for over 20 years, were suffering from behaviours not only just by judges, but against behaviours against themselves by other lawyers, being other barristers or solicitors or clients and the like. And I think at that stage, the bar itself was recognising there was an issue, because unfortunately a lot of people at the bar had become subject to depression. And I think there was one senior counsel at the time who gave a very frank and open speech about his own depression. And because depression's been a thing which has been a great unspoken aspect about all our lives for a long time, but it is an illness like any other. And that was why I think the bar itself set up bar care, and why people started having a closer focus in relation to psychological illness, particularly in white-collar industries, and particularly in a very, at times, stressful job which we have at the bar. The stresses are oftentimes self-induced because we, like a lot of us, we only get things prepared at the last moment. Sometimes they're induced by the solicitor when you're given a document to settle, and you say, well, when's this required by? And they say it tomorrow. Or you take on a case late at night because someone else is jammed and the like. So there's that in itself, they're some of the stresses. But I did speak about the stress of being in court, and even though you may have a tough case, a difficult client, a difficult opponent, having a judge who is equally as difficult as some of those other people can itself be a great cause of stress, because the whole idea, and this is why I did at this particular occasion speak about bullying in the courtroom, because there is a power imbalance, and the power imbalance relates to the fact that the judge is going to determine the case. It may be adversely against your client, and the judge also can be making comments in court, particularly in a crowded courtroom, where a judge might take the view that, well, I'm not going to be trifled with, and I will just make sure that what goes on here might encourage the others to settle their cases, or might encourage others to come to court better prepared, or the like. Now, and so I gave this speech, and then in turn I turned the speech into an article which I had published by the Law Society Journal called Dinosaurs and Bullying Judges. And I might say that after the article was published, it did get a lot of press coverage. And I was walking down Phillips Street one morning, and I met my former head of chambers, Michael Adams. And Michael said, "Oh, hello, Geoffrey. How are you?" And I said, "Oh, I'm good, Your Honour. Judge, how are you?" And he said, "We've read your article." I said, "Oh." And he said, "We've all read it." And he said, "We're waiting for you." and of course, Michael Adams, he figures in one of these cases. I remember Michael had a very great practice, money and crime. You could hear Michael's booming voice, across Phillips Street. At one stage, my room at 4 Wentworth was next door to his, and my client was a former army nurse from World War II, and I think Michael had one of his criminal. When I say criminal, I mean one of his clients engaged in a criminal matter, and the language was a little bit blue, and I closed the door, but in the window from the internal light room, light well at Wentworth Chambers. But the thing is, as a consequence of that article, and I googled the topic today of judicial bullying. It really has become an important topic, not just in Australia, but Tom mentioned the US and the UK experiences is equally as relevant to identify some judges. Now, of course, I've always thought this as far as Anthony Scalia's life was concerned. If they're going to do a movie, I think they'd probably cast Franco Cassaro to be Anthony Scalia, because I think they had a very similar volcanic temper. I would often walk past the corridor here and listen to Franco to talk to his solicitors and clients, and it was Vesuvian in some of the comments he was passing to them. And of course, and I mentioned Scalia, when he was first appointed to the US Supreme Court, it was said that he was going to bring to the court a new gladiatorial spirit, which he certainly did. Now, I asked Fiona through the week to hand out a paper As I said, having given that paper back in 2004, I've been asked on many other occasions to give other talks on the same topic, and over the years there's been a lot more material to work with, and that was the most recent paper I gave last year at a conference of magistrates, and it's been reproduced in the current edition of Workplace Review, which when Richard once graced the cover of it as being the interviewee a couple of years ago. But the paper itself, I don't know if you all got it. I know there's a few of you have got it, but it identifies by reference to examples of poor courtroom behaviour. And as I said, it's not just judge against barrister. It's not just judge against solicitor or judge against witness. The whole idea of judicial bullying is not aimed at judges. It's aimed at the whole profession, because we all need to recognise that litigation is not a form of unarmed combat. Litigation needs to be conducted in a way of respect, with dignity for everybody who happens to come to the courtroom. And I've seen people cross-examine witnesses in a shameful way, which should have been picked up, despite my objections, by the judge. But I think there's been an element over the years that it's acceptable. And I think that our society has moved on somewhat. In one of the articles there, Justice Glenn Martin from the Queensland Supreme Court says perhaps it was a different era years ago, and I think it was. I mentioned earlier that when I first came to the bar back in 82, but having started in the legal profession in 77, there was a big group of people on the bench who were World War II veterans. Not that I'm saying that was, and some of them were the best people you could ever imagine. I think some of them may have been suffering from undiagnosed depression themselves from their war experience, and their behaviour at times was belligerent, undignified and aggressive, particularly to younger practitioners and occasionally to older practitioners who stood up to them. And I think that, like the Australian cricket team now, the sledging in the Australian cricket team is now probably going to be outlawed in the way it has been in the past. I think that our behaviour in court, it starts at the bar. Good behaviour towards one's colleagues is a very important aspect of practice, and I think that you need to understand that it's not just a matter of complaining against judges and their behaviour. It's equally look within your own soul to see how you behave to others and how they behave to you, and I think that and how people behave to witnesses, and I think that's a matter which you really need to take in as a starting point, because as I mentioned in that article, high combative personalities at the bar can end up being high combative personalities on the bench, where you do see it. You do see some people who their behaviour at the bar it totally ill fits them to be members of the bench, which and of course the members of the bench these days recognise that as themselves as a problem, because the Judicial Guide to Conduct, the third edition, which was published last year, recognises that behaviour on the bench is one where dignity to everybody is at the forefront. And in Chapter 4, and this is published by the Australasian Institute of Judicial Administration for Australia and New Zealand. It says this: Chapter 4 deals with the conduct in court of judges. And it says it's desirable to display personal attributes such as punctuality, courtesy, patience, tolerance, and good humour. The trial of an action, whether civil or criminal, is a serious matter, but that does not mean that occasional humour is not out of place in the courtroom, provided that it does not embarrass a party or witness. Indeed, it sometimes relieves tension and thereby assists the trial process. Nevertheless, the entitlement of everyone who comes to court, counsel, litigants and witnesses alike, is to be treated in a way that respects their dignity and should be constantly borne in mind. Bullying by the judge is unacceptable. It is worth remembering that many complaints to the Judicial Commission of New South Wales by litigants and their lawyers have had as their foundation remarks made by judicial officers in the course of proceedings. The absence of any intention to offend a witness or a litigant does not lessen the impact. Now, I mean, that is the instruction now given to judges. And that's very important to bear in mind. But of course, one can understand, you know, how judges can get testy, how they can become rude, and how they can become frustrated by the course of proceedings. And counsel's behaviour may oftentimes be part of that. And if you look at, you know, Barakat against Garitsis, which is the case which is referred to in the paper, that was a dispute between a fighting court between Chris Branson and Michael Adams, and it was clearly you know, when you perhaps look at it, a question of, you know, Chris was probably trying to wind his honour up, and his honour was, you know, was easily wound up, and likewise Escobar and Spindelleri, which is referred to in there as well, where you know, one of our great friends, Stephen, is John Sharp having a brawl in court with Judge Manser in the compensation court, where Manser says to him after Sharpie had closed his case, "Is that it?" And he said, "What do you mean, is that it?" And he said, "Well, have you got any more evidence?" He said, "Don't you tell me how to conduct my case, that's the applicant's case." He said, "Well, if that's the applicant's case, award for the respondent." And you know, you can see how. But of course, I think that I think Richard was in ultimately in appeal proceedings in that case. I think the transcript didn't pick up the tone and the volume of that exchange between John Sharp and Judge Manser. And another case which I've referred to there, where counsel was truly trying to goad the judge, is a famous old case of Tony Belanto Senior against Judge Harvey Pryor. And I think perhaps in these days there was a time when the appeal benches probably protected the judges more than perhaps they would these days. Although Tony Belanto Senior was a feisty character, to say the least. And I understand when he was on 4 Wentworth at a floor meeting, a dispute broke out between him and Neville Wran. And Neville Wran decided to rather priggishly get up and leave the room, but he didn't make it to the door because Tony had punched him. You know, those are the days when the fighting, it was known as the Fighting Fourth, and I think that was how it's got its reputation, because Tony Belanto Senior was actually a boxer, and I don't think Neville Wran ever took a hit as much as he did then, either physically or politically. But in the case of in front of Judge Pryor, it was clear that Tony Belanto was trying to either get an adjournment or get the jury discharged, and a fight broke out between him and Harvey Pryor. And of course, Harvey Pryor, I have to say this from what I hear of him back in those days, from his associate, was no shrinking violet himself. He would have given as good as he got. But this case ultimately was where, because of Belanto's behaviour, Harvey Pryor charged him with contempt and fined him £20. And the court, the full court then of the Supreme Court with Justice Heron, Sugarman and Ferguson, made these remarks about what had happened. From a reading of the entire transcript, an inference could arise that Mr. Belanto harboured resentment against the ruling of the judge, and that he had later lost his temper, which distorted his sense of proportion. Later on it says this: it's counsel's obligation to accept at the time the ruling of the judge on such matters, once finally given. It is not his right to seek ways of going behind it or circumventing it. His, of course, if he feels that the ruling is wrong, is to have his objection noted and at a later time appeal to a higher tribunal. Now, the court then went on to, looking at the transcript, said, from the reading of these printed records, this court obviously cannot obtain a true picture of the real happenings, for where conduct is in question, it depends not so much on the words used per se, but on the attitude, manner, inflection, intonation of the speaker. For example, in deciding whether scorn, reproach or diminution of a court are said to have a result of words used, it is most important to be present and later hear them to see and appreciate the setting in which they were used. And then, but in the course of the transcript, His Honour described Mr. Belanto's conduct at this point as a gross want of regard and respect to the court, as outrageous, disgraceful and unbecoming a member of the bar. He also found it was insulting and disrespectful, an outrageous outburst in the face of the public and the jury. His Honour expressed the view that Mr Belander had insulted the court by his manner of address and mode of shouting, and cited an instance of Mr Belander having shouted back at an observation by the judge. His Honour further said, "I have no control over you at all at any time. You let yourself go in a manner in which I have never seen any counsel perform in my experience at the bar. What you did yesterday I refuse to tolerate in court. You have gone close to the borderline on a number of occasions, not only with me but with other judges." Mr Belander then said, "I've had no complaints from other judges." His Honour said, "Well, I have." He says, "Quite a number of judges object to your manner of conducting a case as to the way you shout and the way you go on in court." Again, during argument, His Honour later said that Mr Belander's conduct was more and more offensive. It was disgraceful and over the odds. And he reiterated, this is almost like a Rococo, a Baroque version of just repeating the same theme, and he reiterated it was more than offensive and demonstrated a gross want of regard and respect to which a court is entitled. Now, the attitude between the bar and bench is a symbiotic relationship, and that includes respect from both sides. So that there's a case where perhaps a counsel went too far, but there are other cases where judges have gone too far. And I know when I did first come to the bar, most of the fearsome judges for a junior barrister were in the district court. The Hospital Road precinct was those days known as the dark side of the moon. We'd encounter people like Ernie Noblanche, Des Ward, Thumper Thorley. And in fact, there's a judge said his nickname was Thumper. Yeah. And what was the other one, Max?
Wally Reddo.
But in those days, but the Court of Appeal in those days had such characters as Athol Moffat, Frank Hutley, and Ray the Rat Reynolds. Ray was given the nickname the Rat by other judges because he accepted an appointment from the state government which no other judge would accept. So he was thereafter known as the Rat. And many years later, a friend of mine lived in the street in Millara, and he said to me, "Do you know a Ray Reynolds?" I said, "Well, why do you ask that question?" He said, "Well, he's on the Neighbourhood Watch Committee, and he feels he has liberty to come into my backyard and check my windows." I said, "You better keep the blinds down." But of course, in my experience in the industrial...
funnel web Freddie Myers.
Well, of course, I'm going to open the whole debate up because a lot of it is war stories, and one way the bar has coped over the years in relation to excessive behaviour by judges and opponents is a debrief back in chambers, particularly over a glass of Chardonnay on a Friday night, and this is obviously clearly this is that great tradition, and I think that has been a way of coping, but it's not necessarily the best way of coping. I think the best way of coping is to try and make sure that such behaviour by judges and by our opponents doesn't happen as much as it has in the past. And I can give you this paper from Justice Martin in Queensland when he was president of the Bar Association. He gave a story at this Judicial College conference about that, where he said a barrister turned up to make his submissions in court one day, and before he started, the judge said, "Before you start, do your clients know you're a complete idiot?" And so he said, "Well, I haven't told him that, Your Honour." But he said, "Can I go with my submissions?" He said, "If you must." And what Justice Martin said was that this particular judge was a repeat offender, well known by the profession, but not well known by the Chief Justice by way of facts and circumstances. And of course, if you are subject to poor judicial behaviour, Justice Martin's view was that you need to record it as if you are taking notes of an accident, of an incident. But he said, he recognised, he said, this young barrister who came to see me about it, he said, didn't want his name to be known because he was afraid of having to appear in front of the judge at some subsequent time in which he said he practiced in that jurisdiction. So that there's that tension involved in, if I make a complaint, how am I going to be perceived, not just by that judge but by others, and that is a difficult thing. But of course, when and that's probably why the Bar Association needs to be a bit more robust in its approach on these sort of issues to protect young counsel. And of course, another paper at that same conference was given by a professor who had done a study regarding resilience of junior members of the profession, and his name is Anthony Foley, and he said that it's junior members of the profession who are mainly the subject of bad behaviour by judges because of the power imbalance, and that's equally where we, as perhaps I say we, not all of us, but some of us who are more senior practitioners do need to protect those who have just recently come to the bar from such behaviour. And perhaps one way of protecting them is not to pass them the hospital pass. That sounds a silly thing to say, but the example Professor Foley gave was of a junior solicitor in the West Australian Legal Aid Office who was given a brief to go up to a particular magistrate on a matter which had been adjourned 7 times already. And she got up before the magistrate, and he just exploded because this case had just been mucked around for over a year in front of him, and unfortunately that young solicitor, she committed suicide later that day, and so there's an instruction to all of us to make sure that we don't pass people cases that they're not probably ready for, because and don't pass them cases where there's already some disasters in it already. I think that if that's the case, a more senior member with perhaps more resilience should be given the work to do. And if there's a major problem in a case, I think that that concept of the hospital pass is probably very unfair. And I would have thought that there was joint liability in terms of what happened to that young solicitor on that occasion because of the nature of the case and the fact that this same magistrate had been trifled with perhaps on too many occasions by that office. And one good thing which did come out of that case was, I think, there was protocols put in place by the Legal Aid Commission in Western Australia to make sure that people of that junior status in the profession were not given cases like this because of its earlier problems. Now, and my other war story from the commission is Frank Liddy. Frank was he to be fair, he did have PTSD. He was subject to a jeep rolling over in New Guinea during the war. So a lot could be accepted about Frank. But one day up in Grafton, I turned up late for an 88F case against Russell Peterson, and I asked for some time for discussions, and I said no, because you're already late. There's no time for discussion. Just run your case, Mr. Phillips. And so I did, and then all day, mercilessly, he just threw brickbats at me, and I spoke to Russ and asked for any offers. None. After this morning's performance, he says my client's not making any offers at all. And then Frank had a way of dealing with things. He had this tipstaff, and this tipstaff came to me. He said, "Have you taken their offer yet?" I said, "They're making no offers." And that got back to the judge, because when I sat down and my case was concluded, he then did the same to Russell for the next 2 hours the next day, and the case settled at lunch on the second day. And so Frank had his magic, but of course, when you look at some of these examples in my paper, I've taken a lot of judges are bullies because in order to make sure you settle the case. And I've seen cases where outrageous behaviour's been on the basis that they don't have to write a judgment. And of course that just gets, that's equally a kind of an action which is really totally inappropriate. Dyson Hayden, in one of the papers which, in a recent paper he gave in London, did talk about lazy, ignorant, rude bullying judges in Australia, and so that it's certainly recognised. But Dyson Hayden a couple of years ago also spoke about judges being bullies against each other, particularly on the High Court, in trying to make sure that you come across to my point of view. And of course, you always know with Dyson Hayden, if anyone's going to write their own decision, it was him, because he would not put up with that.